right, good morning and welcome everyone. My name is Keith Neely and I'm an attorney at the Institute for Justice, and we're holding today's press conference in support of an amendment to Senate Bill 96 here in New Hampshire that would essentially end qualified immunity in the state of New Hampshire. And I'm joined by several friends and colleagues who I'm going to introduce here in just a moment, and they're each going to talk a little bit about why they support this amendment to Senate Bill 96. So behind me to my right, I'm welcome and joined by Representatives Tony Lekis and Paul Birch, a Republican and a Democrat respectively, showing exactly how bipartisan support is for ending qualified immunity reform here in New Hampshire and for holding government officials accountable. Next to them, I'm joined by former New Hampshire Supreme Court Justice Charles Douglas, and he's going to be talking about the importance of qualified immunity reform from a legal perspective. And last but not least, I'm joined by Ben Cohen and Jerry Greenfield, but you might know them by their first names, Ben and Jerry. They are representing the entrepreneurial community here, joining us from neighboring Vermont. And they're all going to be talking a little bit about why it's really important today to reform qualified immunity and to start here in New Hampshire. So take it away, Tony. Oh, Paul. Sorry. Go ahead, Paul.
Thank you, Keith. My friends, I welcome you all to this press conference regarding this amendment to the Lee Act bill that I will file tomorrow in House Judiciary. This legislation guarantees that the citizens of our state have a right to go to state court for redress of harms done to them by the government. This legislation is not as complicated as some would make it. An activist Supreme Court tried an experiment in 1982 to provide qualified immunity to protect some government actors. That experiment has been widely considered a failure. Now the United States Congress and many states are seeking to end this failure. This legislation does three things. It returns the law to how it was pre-1982. It provides a path to state court in addition to a currently existing route to federal court, and it shifts the burden of any financial penalty and costs from the individual bad actor to his or her governmental employer. Why is this legislation necessary? When police wrecked a woman's home by bombarding it with tear gas grenades after she agreed to let them in to arrest her former boyfriend, no civil liability due to qualified immunity. When a sheriff shot a 10-year-old boy while trying to kill his dog, no civil liability due to qualified immunity. When a law enforcement officer sicked a police dog on a subject who had already surrendered, was sitting on the grounds with his hands up, no civil liability due to qualified immunity. When police officers stole cash and property worth $225,000 while executing a search warrant, no civil liability due to qualified immunity. Then there's the question of the Sununu Youth Center, where in excess of 100 claims have been made of sexual and other abuse of children by state employees. If that happened, and I don't know if it did happen, but if it did happen, should those alleged abusers and their employer be protected from civil suit from their victims because of qualified immunity? To clear up a few misconceptions, this legislation has nothing to do with frivolous lawsuits. Studies in Colorado and California debunk the claim that municipal costs will increase to any significant degree with this type of legislation. State, county, and municipal employees who are acting in a judicial or legislative capacity, select board members, aldermen, commission members, and the like, will keep their immunity from suit in their personal capacity, as they have always had. And acts of state employees are to be examined in the light of what a reasonable state employee should have done given all the circumstances existing at the time the action was taken. Our founders in New Hampshire had it exactly right in 1784, when they wrote Part 1, Article 14 of our Constitution. Every subject of this state is entitled to a certain remedy by having recourse to the laws for all injuries he may receive in his person, property, or character, to obtain the right and justice freely, without being obliged to purchase it, completely and without any denial, promptly and without delay, conformably to the laws. As granite staters, we believe that the doors of our courts must be kept open to redress wrongs done to our citizens. That is what this legislation will accomplish.
Hello, I'm Representative Tony Lekis. Thank you for coming to this press conference. All of us are expected to know the law and to not violate it. You might expect that the employees of the government of New Hampshire would be expected to know what the rights of those they ultimately work for, the people of New Hampshire, are. That was the case through almost all of this nation's history. Unfortunately, in 1982, the U.S. Supreme Court removed the presumption that government employees would know what actions violate people's rights. They were not held liable for their actions unless the courts had previously decided that the particular behavior they engaged in was a violation of rights. This has led to some being immune from civil liability who have committed acts that anyone would consider an obvious and gross violation of rights. It is time to put that to an end. This is not an anti-police amendment, as some have claimed. By holding the government employers liable, it recognizes that it is the employer's responsibility to hire, train, and supervise carefully. They must provide a work environment that promotes professional behavior. It's not right to expect employees to act in a professional manner if their employer does not provide an environment that encourages and rewards such behavior and refuses to accept unprofessional behavior from its employees. Almost all government employees perform their duties in an appropriate and professional manner. We can make it easier for them to continue to do so by providing incentives for the employer to prevent any unprofessional conduct. Good employees should not be put in a position of having to resist the occasional employee who may behave unprofessionally. As was mentioned, experience in other states that have eliminated qualified immunity has shown that the increase in costs has been minimal. That is both because the incidence of unjustified suits is very low and because few government employees are violating people's rights. The first part of the New Hampshire Constitution is our State Bill of Rights. In that Bill of Rights is a statement of the purpose of coming together to form this state. Article 3, Society, its organization, and purposes. When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others. And without such an equivalent, the surrender is void. Protecting the rights of the people of New Hampshire is the core purpose of the state. It is the obligation of the New Hampshire legislature to protect those rights as required in the Constitution. If there is no effective remedy when rights are violated, we will have failed in that duty. This amendment is intended to provide that remedy. Thank you.
Good morning. I'm Chuck Douglas, and I'm here to talk about a couple of folks who have had the unfortunate experience of dealing with the police who are not law-abiding and do not respect the rights of others. In 2013, a woman named Wendy Lawrence was stopped on the interstate for what the police officer thought was drunk driving. She drove off. He chased her into Manchester, where she slowed down, came to a complete stop. Unfortunately, another officer with the state police didn't get the word the chase was off, let her go. He stood in front of her car and fired 11 rounds into the windshield, killing her. That's a photo of her car just about where the officer was standing when he fired every shot he had in his gun. This is not the way we handle DWIs in New Hampshire. It is not a capital offense. That's the kind of conduct that should never be given qualified immunity. A couple of years ago, a guy in Nashua named Warren Picard, who's been in and out of the system. He's bipolar, he medicates by drinking, and one night a couple of years ago, he's out on the rail trail in Nashua, and he relieves himself when a police officer arrests him. As he gets to the cruiser, he's handcuffed. He is not fleeing, but he asks why he's being arrested, and that officer loses it and slams Warren's face into the roof rack, sending him to the hospital. That, again, is not a cop who should be getting qualified immunity. The defense needs to go and let 12 people on our juries decide whether or not that kind of conduct that I showed you is appropriate or not. Thank you.
I'm Ben Cohen. Jerry and I are here representing the national campaign to end qualified immunity. We are a national coalition of 16 organizations, from Cato and Americans for Prosperity to the Leadership Conference on Civil Rights and the ACLU. You know, in the 1800s, there was a big problem in our country that police were breaking the law and abusing their authority. So Congress passed a piece of legislation specifically to allow people whose rights had been violated by the police to sue them in civil court. Then, in the 1980s, the Supreme Court eviscerated that decision. We have a problem in our country today. There are some policemen that are breaking the law and abusing our citizens. You know, so people want to hold cops accountable. That sounds pretty reasonable. A majority of the U.S. population, based on a Pew survey, wants to hold cops accountable and to end qualified immunity. Clarence Thomas and Sotomayor, they both want to end qualified immunity. It was Sotomayor who said that qualified immunity allows cops to shoot first and think later. That's absurd. Who doesn't want to be held accountable? You know, nobody really wants to be held accountable. But in order to get anything done, in order to have an organization in which people abide by rules and regulations, you need to hold them accountable. Jerry and I found that out in business. If you don't have accountability, you ain't got nothing. And all we're asking is to hold cops who break the law accountable. So cops, who's against that? Cops are against that. They don't want to be held accountable. Well, I get it. You know, if I'm given the choice, do I want to be held accountable or not accountable? I'll take non-accountable. But cops are the only element of our society that we arm and allow to use force all the way up to lethal force in our name. That element of society really needs to be held more accountable than anybody else. But instead, we give them qualified immunity, which in practice is unqualified impunity. We give them qualified immunity, which in practice is unqualified impunity. You know, when police officers abuse their power and they are not held accountable, they are above the law and justice is in the toilet.
Thank you, Ben, and good morning. Ending qualified immunity is not anti-police. It is pro-good policing. It is about accountability for police and justice for the victims whose constitutional rights have been violated. In the last year, qualified immunity has been ended or limited in Colorado, New Mexico, Connecticut, Massachusetts, and New York City. There are bills and discussions in about a dozen more states. Who is against ending qualified immunity? Police unions and some municipalities. Neither group wants to be held accountable legally or financially when law enforcement breaks the law. What are the objections we hear? We are told that immunity is already weak, that it is qualified. Well, there should be no form of immunity when an officer commits an egregious act of excessive force. Ending qualified immunity will not open doors to frivolous lawsuits, as officers already are protected by various legal tests, including the reasonableness standard in their day-to-day work. How about the idea that ending qualified immunity will drive people away from the profession? Recent studies show that police have been driven away more by the loss of the trust of the communities they serve than by the possibility they may lose an obscure legal protection. After New York City ended qualified immunity, the Police Benevolent Association, the Sergeants Benevolent Association, and the Captain's Endowment Association sent a letter to their members advising them, quote, "You are strongly cautioned against engaging in any stop and frisk unless doing so for your own or another's safety. Search of a car, residence, or person unless you are certain that you are clearly and unequivocally within the bounds of the law." That is a standard that should be both obvious and the law of the land everywhere. Thank you.
Well, thanks to all of you for speaking. I'd actually like to kick off some of the questions myself here, and the first one's going to be for Representatives Birch and Lekes. I know that the legislation that's being introduced as an amendment to Senate Bill 96 is a little bit different than the first round of legislation that was introduced as part of House Bill 11. Could one or both of you talk about some of those differences?
Thank you for the question. What we did in crafting this amendment is to make a few changes. Some are technical language. I won't get into that. But we decided to, first of all, make it clear that the individual police officer himself or herself or the municipal employee himself or herself will not be sued by name, but that their employer will be sued. And that is a major change from the prior bill. We have clarified in the bill itself that immunity for municipal, state, local, and state officials, if they're acting in their judicial capacity or in legislative capacity, that immunity will still hold. We have, and those are probably the two major ones. I think there's some others, but they escape my mind at the moment.
Thank you, Representative Birch. I have actually another question as well for former Justice Douglas. You know, you talked about some of the more egregious examples of qualified immunity. You've served as a lawyer here and as a judge in the state of New Hampshire now for some time. Could you talk a little bit about how widespread this problem is? I'm sure over the course of your career you've seen many examples of this. Could you touch on exactly how often officers are able to claim this?
Luckily, in New Hampshire, it is not a widespread problem. There is not a systemic police abuse problem. Once in a while, in one of the towns or cities, you'll get a run of these cases. Usually, the police-imposed violence is not quite as bad as some of the ones I showed you earlier. But there are departments that never get sued. There are police officers who go 30 and 40 years never having discharged their weapon, when there are other officers who have been involved in at least 2 fatal shootings. Those latter officers are the ones that are the problem. And unfortunately, the only way you can get at it is to put pressure on the town, the city, or the state to get them out of active police work and to hold them accountable. But we're fortunate that it is not a widespread problem, and I don't think it is a systemic problem with 1 or 2 exceptions in the state. And usually a change at the top leads to a change up and down the line of officers. So I think we're blessed that way, but those who are bad need to be accountable. And that's why the amendment and the proposal that the 2 representatives have to Senate Bill 96 is important.
Thank you, Justice Douglas. And lastly, I have a question for Ben and Jerry. You know, you talked a little bit about this when you first spoke about the importance of accountability in business. And I was wondering if you could talk a little bit about how both of you came to support ending qualified immunity reform. You know, when I think of business, and well, when I think of Ben and Jerry's ice cream, I don't immediately think of ending qualified immunity. So could you talk a little bit about how you guys came to support this issue and why it's so important to you?
When we became aware that there are police in our country, bad cops that are abusing their authority, and when we became aware that those bad cops are getting off scot-free or with a slap on the wrist because of this absurd legal doctrine whose basis is essentially law enforcement officers are not expected to know the law. That's absurd. So when we realized why these cops are getting off when they abuse people, and that the reason is qualified immunity, just as a matter of justice, decency, we said we're going to put our whole selves into this issue and form this large coalition.
Yeah, we should understand that the only people who benefit from qualified immunity are bad cops. Good cops have nothing to worry about. This is not anti-police. There are so many wonderful police who do a great job. We say, love the good ones, but you have to prosecute the bad ones.
If I may, I want to make sure our conversation is broader than just police officers and correctional officers, because this bill encompasses government actors. I mentioned before the Sununu Center, which right now it could be argued that misbehaving government employees cannot be successfully sued for abusing children. So we don't want to limit the conversation only to police. If I went with one of my friends to McDonald's and I ordered a Big Mac and a counter person put in 5 or 6 ghost peppers in my Big Mac, and I landed up having to go to the hospital, having my stomach pumped, perhaps damage to my vocal cords or my esophagus, and maybe I'd want to sue McDonald's. So I go sue McDonald's. Can you imagine that if McDonald's came back and said, oh, maybe you were harmed, maybe you weren't, but the legislature or the courts have given us immunity. You can't sue us because it would cost money and it might cost some jobs. So it's kind of, we have an ollie in free card. You'd find that pretty ridiculous. If somebody came and painted your house and they did a terrible job and you wanted to sue their company and the company said, oh, we've got immunity. You know, the legislature or the courts have said, we're ollie in for you. You can't sue us for a bad job. You'd think that's ridiculous. We're not asking for anything different than having government actors, government employees, subject to the same standards as people who paint your home or serve you your food at a fast food place.
So to follow up on the statements that this is not anti-police or anti-government employee in general, consider the situation where there is someone who is a police officer or a government employee in some other department. And they want to serve in an honorable manner. They want to do what's right. But they're unfortunate enough to be in a department where the culture doesn't support that. And where there's one or more other employee, officer or employee in another department who is doing things that they shouldn't be, violating people's rights. I mean, think about it from that employee's point of view. They're in a terrible situation. If they want, they may feel a duty to bring that issue up, but they would be seen as snitching on the other employees. They might be concerned that they would not get support from their management. And the other alternative would be either to just turn a blind eye, which they might, have a moral objection to, or to leave the employment as well, or to do something else. So this actually would be a way to support officers or other employees who want to do the right thing to be able to do so without being put in such a terrible position.
Well, thank you, Representatives Birch and Lekis, and thanks to everyone for coming here today. A special thanks to those of you who showed up to show support for ending qualified immunity here in New Hampshire. And a special thanks as well to the Americans for Prosperity chapter here in New Hampshire for helping to make today's event a reality. Again, my name is Keith Neely, and I'm an attorney with the Institute for Justice, and all of us are going to stick around to answer any additional questions that you may have. Thanks for coming.